Chapter 3, Appeal. Article 229, Appeal. Decisions, awards, or orders of the labor arbiter are final and executory unless appealed to the Commission by any or both parties within 10 calendar days from receipt of such decisions, awards, or orders. Such appeal may be entertained only on the following grounds. A. If there is a prima facie evidence of the abuse of discretion on the part of labor arbiters. B. If the decision, order, or award was secured through fraud or coercion, including graft and corruption. C. If made purely on question of law. And D. If serious errors in the finding of facts are raised which cause grave or irreparable damage to or injury to the appellant. What is an appeal? An appeal means the elevation by an aggrieved party of any decision, order, or award of a lower body to a higher body by means of pleading, which includes the assignment of or enumeration of errors, the supporting arguments, and the relief of the assistance prayed for. It also refers to the right to seek the review by a superior court of the judgment rendered by the trial court. An appeal can be either discretionary or of right. An appeal of right is one that the higher court must hear if the losing party demands it, while a discretionary appeal is one that the higher court may but does not have to consider. The person pursuing an appeal is called appellant, while the person defending the lower court's ruling is the appellee or respondent. For example, in case of judgment involving a monetary award, an appeal by the employer may be perfected only if the employer posted the cash or surety bond issued by a company duly credited by the Commission in the monetary amount equivalent to the award posted in the judgment appealed for. Or, in any event, the decision of the labor arbiter reinstating a dismissed or separated employee as the reinstatement aspect is concerned, the dismissed or separated employee shall be admitted back to work under the same terms and conditions prevailing prior to his dismissal or separation, or can be merely reinstated in the payroll, depending on the option of the employer. Requisites for perfection of appeal. If an appeal is not perfected, it means that it failed to observe some technical or procedural requirements for which reason it may be dismissed or rejected. The following are the requisites for perfection of an appeal from the labor arbiter to the NLRC division. The appeal should be: Number 1. Filed within the reglementary period or the time limit specified by the law. Number 2. Verified by appellant himself in accordance with Section 4, Rule 7 of the Rules of Court. Number 3. In the form of memorandum of appeal in 3 legible typewritten copies which shall state the grounds relied upon, the supporting arguments, the relief prayed for, and the date of the appellant receive of the appealed decision, resolution, or order. The appeal memorandum should be accompanied by a certificate of non-forum shopping, proof of service on the other party, proof of payment of the appeal fee, and cash or surety bond. In all cases, the appellant shall furnish a copy of the memorandum of appeal to the other party, who shall file an answer not later than 10 calendar days from the receipt of thereof. Within 10 days after receiving the appeal memorandum, the appellee should file his answer, because a mere notice of appeal without complying with other requisites shall not stop the running of the 10-day period for perfecting an appeal. The 10-day period provided in Article 229 refers to 10 calendar days, not working days. This means that Saturdays, Sundays, and legal holidays are included in the counting of the 10-day period. If the 10th day to perfect the appeal from the decision of the labor arbiter to the NLRC falls on Saturday, Sunday, or holiday, the appeal shall be made on the next working day. The Commission shall decide all cases within 20 calendar days from the receipt of the answer of the appellee. The decision of the Commission shall be final and executory after 10 calendar days from the receipt thereof by the parties. On the important note, To discourage frivolous or dilatory appeals, the Commission or the labor arbiter shall impose reasonable penalty including fines, censures upon the erring parties. Dilatory appeals means that the appeal is being prosecuted for an improper motive, like to harass the respondent or to delay the effect of an adverse judgment. While an appeal is frivolous when viewed under the objective standard, any reasonable attorney would agree that the appeal is totally and completely without merit. Perfection of appeal requires posting of bond on time. As stated in this article, the appeal from the labor arbiter's decision is not perfected if cash or surety bond is not posted within the 10-day appeal period. This is also clear in Section 4 and Section 6, Rule 6 of the 2011 Rules of Procedures of the National Labor Relations Commission. As the court said, as there was no appeal bond filed together with the appeal memorandum within 10 days period provided by the law for the perfection of appeal, it follows that no appeal from the decision of the labor arbiter has been perfected. Accordingly, the decision of the labor arbiter became final and executory upon the expiration of the regimentary period. It bears stressing that the bond is essential and cannot be without to the perfection of appeal from the labor arbiter's monetary award. This article also mentions Section 4 and Section 6, Rule 6 of the 2011 Rules of Procedures of the National Labor Relations Commission. Section 4, Requisites for Perfection of Appeal. Number 1. Filed within the regimentary period. Number 2. Verified by the appellant himself or herself in accordance with Section 4, Rule 7 of the Rules of Court as amended. Number 3. In the form of memorandum of appeal which shall state the grounds relied upon and the arguments in support thereof, the relief prayed for, and with the statement of the date the appellant received the appeal decisions, award, or order. Number 4. In 3 legible typewritten or printed copies, and Number 5. Accompanied by first, proof of payment of the required appeal fee and legal research fee. Second, posting of a cash or surety bond as provided in Section 6 of this rule. And third, proof of service upon the other parties. The Section 6 tackled about the bond. So, in the case of the decision of the labor arbiter or the regional director involves a monetary award, an appeal by the employer may be perfected only upon the posting of a bond, which shall either be in the form of cash deposit or surety bond in an amount equivalent to the monetary award, exclusive of damages and attorney's fees. So, in the case of surety bond, the same shall be issued by the reputable bonding company duly accredited by the Commission and shall be accompanied by original or certified true copies of the following. A. A joint declaration under oath by the employer, his or her counsel, and the bonding company, attesting that the bond posted is genuine and shall be effected until final disposition of the case. B. An indemnity agreement between the employer, appellant, and bonding company. C. Proof of security deposit or collateral securing the bond, provided that a check shall not be considered as an acceptable security. D. A certificate of authority from the Insurance Commission. Letter E. Certificate of registration from the Securities and Exchange Commission. Letter F. Certificate of authority to transact surety business from the Office of the President. Letter G. Certificate of accreditation and authority from the Supreme Court. And letter H. Notarized board resolution or secretary's certificate from the bonding company showing its authorized signatories and their specimen signatures. The effect of appeal from arbiter to National Labor Relations Commission. According to this article, without prejudice to immediate reinstatement pending under Section 6 of Rule 11, and should also see Section 18 of Rule 5 and Section 9 of Rule 11, because once appeal is filed, The labor arbiter loses jurisdiction over the case. All pleadings and motion pertaining to the appealed case shall thereafter be addressed to and filed with the Commission. Issues on appeal. Remedies. The Commission shall, in cases of perfected appeals, limit itself to reviewing those issues which are raised on appeal. Those which are not raised shall be final and executory, read and ready for implementation. The issues raised on appeal, however, shall be open for review. That is, the National Labor Relations Commission is legally authorized to decide or take action on the questions brought up on appeal. Extraordinary remedies. The topics below will continue tracking down the appeal procedure from the labor arbiter to the Commission, but at this point, we need to take a brief look at the significant new rule introduced in the 2011 National Labor Relations Commission Rules of Procedure. The new rule allows the party aggrieved by any order or resolution of the labor arbiter, including those issued during execution proceedings, may file a verified petition to annul or modify such order or resolution. The petition may be accompanied by an application for the issuance or of a temporary restraining order and of writ of preliminary and permanent injunction to join the labor arbiter or any person acting under his or her authority to desist from enforcing said resolution or order. The petition filed under this rule may be entertained only on the following grounds. Letter A. If there is a prima facie evidence of abuse or of discretion on the part of the labor arbiter. Letter B. If serious errors in the findings of facts are raised which is not corrected would cause grave or irreparable damage or injury to the petitioner. Letter C. If a party by fraud, accident, mistake, or excusable negligence has been prevented from taking an appeal. Letter D. If made purely on questions of law. Letter E. If the order or resolution will cause injustice if not rectified. So, when and where is the petition under this rule is filed? So, it is filed not later than 10 calendar days from the receipt of the order or resolution of the labor arbiter. The aggrieved party may file a petition with the Commission furnishing a copy thereof to the adverse party. Conciliation and mediation. Even at the appeal stage of a labor arbiter's decision, amicable settlement is a preferred mode. The 2011 Rules of Procedure of the National Labor Relations Commission, Rule 7, Section 2, states that in the exercise of its exclusive or original and appellate jurisdiction, the Commission may exert all efforts towards the amicable settlement of the labor dispute. The settlement of cases on appeal to be valid and binding between the parties shall be made before the Commissioner of his authorized representative. So, the conduct of mandatory conciliation and mediation conference has been suspended unless otherwise set by the handling labor arbiter in his or her discretion. So any conciliation or mediation conference, as far as feasible, shall be done through video conferencing or other electronic means. If any of the parties has no access to technology for electronic hearings, then National Labor Relations Commission may provide a hearing room and laptop or tablet for their use. The labor arbiter shall exert all efforts towards the amicable settlement of the case.
National Labor Relations Commission or NLRC decision. The decision of the Commission shall be final and executory after 10 calendar days from receipt by the parties. NLRC decision ay after 10 days dapat makapag-execute na ng final decision yung Commission. So under the 2011 rules of the National Relations Commission, pwede po silang mag-file ng motion for reconsideration yung both parties at yung magiging decision ng commission is nakabase sa mapapatunayan. So, dapat yung pag-file ng motion is within 10 days lang after ng receipt of the order. Tapos po, kung may partido na di nakapunta sa araw ng appeal, pwede ulit silang mag-file ng motion for reconsideration. Pero pagtapos na at nakapag-decision na yung commission after ng appeal nila, di na ulit sila pwede mag-file ng another motion for reconsideration dahil ma-violate yung rules at magiging grave abuse of discretion.
Petition for certiorari with the Court of Appeals. If the motion for reconsideration fails and there are merits in pursuing the case, the party may also seasonably avail itself of the special civil action for certiorari under Rule 65 of the Rules of the Court. Ang petition for the certiorari with the Court of Appeals ay pag hindi na pagbigyan yung case ay pwedeng pagbigyan ng special civil action at yun ang tinatawag na certiorari. Pero hindi lahat ng kaso ay binibigyan ng ganun. Pwede lang i-consider yung certiorari pag kulang ang ebidensya ng isang case. Where to file petition? The St. Martin ruling. From the NLRC, the case may go to the Court of Appeals. The Supreme Court has ruled in the St. Martin case that the both Supreme Court and the Court of Appeals have the power to review NLRC decision. Ang where to file petition, ito yung petition na pinafile sa Court of Appeal. And yung Supreme Court ang namumuno sa St. Martin case. Both Supreme Court and the Court of Appeals ang may kakayahang i-review ang decision ng NLRC. Effect on NLRC decision. A petition for certiorari filed with the Court of Appeals or the Supreme Court shall not stay or suspend the execution of the sealed decision of the NLRC unless a restraining order is issued by the Court of Appeals or the Supreme Court. Section 4, Rule 11, NLRC Rules 2011. This is a petition for certiorari or for re-examination of action of the lower court. Hindi dapat ihinto or isuspend ang execution o sale decision ng NLRC unless kung may restraining order galing sa Court of Appeals or sa Supreme Court. Certified true copy of NLRC decision. Numerous decisions issued by the Supreme Court emphasize that in appeals under Rule 45 and in special civil actions for certiorari under Rule 65 in relation to Rule 46 and 56, what is required to be certified is the copy of the question judgment, final order, or resolution. It means that all decisions from NLRC must be certified true copy to prove that everything is true and right on the paper that find in the case. Finding of facts. Final. Quasi-judicial agencies like the National Labor Relations Commission have acquired expertise because their jurisdiction is confined to specific matters. The quasi-judicial agencies such as the NLRC must all findings have evidence to support a case and for the outcome of the findings to be more accurate. Exceptions. However, the Supreme Court has never hesitated to exercise its corrective powers and to reverse administrative decisions in these following cases. The Supreme Court did not hesitate to use their ability to correct what they found to be wrong, such as those unbelievable or wrong, not pure truth, or they don't have enough evidence in that case. Article 230. Executions of decisions, order, or awards. The voluntary arbitrator may, upon his initiative or motion of any interested party, issue a writ of execution and a judgment within 5 years from the date it becomes final and executory, requiring the sheriff to execute the final decision, order, or award. If an appeal has been filed, a writ of execution may be issued when there is an entry of judgment as provided for in Section 14 of Rule 7, Injunction against NLRC from a regular court. Precedents or previous court decisions abound confirming the rule that regular courts, example regional trial courts, have no jurisdiction to act on labor cases or their incidents, including the executions of decisions, awards, or orders. Walang karapatan ang mga regular courts or mga mabababang courts sa pagde-decide regarding sa cases about sa labor. Third-party claim under the NLRC Rules of 2011. Under Rule 11 of the NLRC Rules of 2011, a third-party claim should be filed within 5 days from the last day of posting or publication of the notice of execution sale. Otherwise, the claim is forever barred.
If the property levied is claimed by any persons other than the losing party, such person may file the third-party claim not later than 5 days from the last day of posting or publication of the notice. The third-party claim shall be filed with the Commission or labor arbiter where the execution proceeding is pending, with proof of service of copies thereof to the sheriff and the prevailing party. Article 231. Contempt powers of the Secretary of Labor. In the exercises of his powers under this code, the Secretary of Labor may hold any person in direct or indirect contempt and impose the appropriate penalties therefor. Ito ay maaaring magkaroon ng sino mang tao upang magdirekta at hindi idirektang magpahamak at magpataw ng naaangkop na mga parusa dito.
The Labor Code of the Philippines, written by Azucena. In Title 3, we are talking about the BLR or the Bureau of Labor Relations. In Article 232 of Bureau of Labor Relations, it says that the Bureau of Labor Relations and the Labor Relations Divisions in the regional offices of the Department of Labor shall have original and exclusive authority to act at their own initiative, or upon request of either or both parties on all inter-union and intra-union conflicts, and all disputes, grievances, or problems arising from or affecting labor management relations in all workplaces, except for those arising from the implementation or interpretation of collective bargaining agreements, which shall be the subject of grievance procedure and or voluntary arbitration. It also includes that the Bureau shall have 15 working days to act on labor cases before it subjects to extension by agreement of the parties, as amended by Section 14 of the Republic Act No. 6715 on March 21, 1989. In here po, the Bureau of Labor Relations is under by the DOLE means the original and the exclusive authority to act at their own initiation or upon request of either or both parties on all inter-union and intra-union conflicts, grievances, or problems arising from or affecting the labor management relations in all workers, and have 15 days to act on labor cases subject to extension of agreement of both parties. When we say a BLR or Bureau of Labor Relations is siya yung nag-aayos ng problema at isa na dito si collective bargaining. Collective bargaining, a quick review lang is, collective bargaining is a written contract between the employer and the union representing the employees. And dito naman po papasok si mediator, arbitrator, or med-arb. It refers to an officer in the DOLE regional office or in the Bureau of Labor Relations who is authorized to hear and decide representation cases, inter or intra-union disputes, and related labor relation disputes. It involves independent union, chartered locals, and worker association, but if the complaint involves a federation or a national union, it shall be filed with the BLR itself or the Bureau of Labor Relations. Di bale, siya yung tao ni BLR that will be the judge na makikinig and yung gumagawa ng desisyon. Yung mga kaso na hinahawakan niya can be either inter-union disputes or intra-union disputes. When we say inter-union disputes, in short, it refers to any conflict between legitimate labor unions, but let me discuss here further. It refers to any conflict between legitimate labor unions under Directive Order No. 40-03 Series of 2003. It is amending of the implementing rules of Book 5 of the Labor Code of the Philippines. It includes the long list of inter or intra-union disputes. It also recognizes a second category called other related labor relations disputes. This includes any conflict between the labor union and the employer or any individuals, entity, or group that is not a labor organization or workers association. For example, is may dalawang union na may dispute kung sino ang magpe-present in behalf of the employees. By representing this will lead to the representation cases refer to the preceding intended to determine which one among rival unions should be officially designated or certified as the exclusive representative of the employees in bargaining collectively with their employer. Next is intra-union dispute. It refers to any conflict between members of the union. Example, there is a dispute with the member of the union. Like may problema yung member sa mismong union kung saan siya nakaparte. And then next is, when it comes to appeal, the decisions of the med arbiter and the regional director under this article may be appealed to the Bureau by any of the parties within 10 days from the receipt thereof. Copy furnish the opposing party the decision of the bureau director in the exercise of his original jurisdiction may be appealed to the office of the secretary by any party within the same period with notice to the opposing party. Example is, gusto mo lumabas pero hindi ka pinayagan ng tatay mo, then pwede ka pang humabol ng apela na sandali lang po yun. Kaya yun. Let's move on to Article 233, Compromise Agreements. Any compromise settlement, including those involving labor standards laws voluntarily agreed upon of the parties with the assistance of the Bureau or the regional office of the Department of Labor, shall be final and binding upon the parties. The National Labor Relations Commissions or any court shall not assume jurisdiction over issues involving therein except in the case of non-compliance thereof or if there is a prima facie evidence that the settlement was obtained through fraud, misrepresentation, or coercion. Compromise, release, and quitclaim. A compromise is a contract where the parties, by taking reciprocal concessions, avoiding litigation or put an end to one already commenced. In our 2028 Civil Code, compromise agreements involving labor standard cases must be reduced to writing and signed in the presence of the regional director or his duly authorized representative. Si compromise agreement daw po is, yung agreement is between the employer and the employee and doon nakasulat yung about sa mga claims and benefits ng isang employee. Example, sa company ni Mr. Pasado is magko-compromise silang dalawa ng empleyado niya na si Mr. Andy Lim ng isang written and legal agreement na pinagkakasunduan nilang pareho between the both parties, and kapag okay na sila pareha sa agreement, that will be the final and binding upon the parties. Except, kapag tinakot ni Mr. Pasado si Mr. Andy Lim para pumirma sa agreement, this will lead to be invalid the compromise agreements. The law looks with disfavor upon quick claims and releases by employees to enunciation who are inveigled or pressured into signing them by unscrupulous employers seeking to evade their legal responsibilities. Ito yung pumirma sa employee na hindi niya nakukunin yung claim niya. An example for this is, si employee na pangalanan na lang nating Mr. Pride is pumirma sa kasunduan na hindi niya nakukunin yung pera na nilaan sa kanya ni Mr. Mapagbigay, his employer. Summing up, a compromise agreement may be valid and binding only if the agreement is voluntarily entered into it and represents a reasonable settlement of the claims. It may be invalidated if the amount purportedly received by the complainant is unreasonably lower than what is legal due. Ito naman yung kapag voluntary na pumayag si Mr. Pride and Mr. Mapagbigay sa kasunduan, this is a valid and binding. Pero pwede ma-invalidate kapag na-receive ni Mr. Pride is mas mababa sa legal due niya or napatunayan na tinakot lamang siya para pumirma. Furthermore, the compromise settlement should be executed with the assistance of the Bureau of Labor Relations or the regional office of the DOLE pursuant to Article 233 of the Labor Code. A compromise agreement by union officers must be authorized by non-union members. The authority must be produced in evidence. each laborer must authorize the union officers to enter into compromise before the laborer's right may be affected. Dito naman is tatlo na sila magkakasama. Kasama na dito si Mr. Pride, si Mr. Mapagbigay, and si BLR. And then let's move on to Article 234, which is endorsement of cases of labor arbiters. Except as provided in paragraph B of this article, the labor arbiter shall entertain only cases endorses to him for compulsory arbitration by the Bureau or by the regional director with a written notice of such endorsement or non-endorsement. The endorsement or non-endorsement of the regional director may be appealed to the Bureau within 10 working days from the recipient of the notice. The parties may at any time, by mutual agreement, withdraw a case from the conciliation section and jointly submit it to the labor arbiter, except deadlocks in collective bargaining reappealed by Section 16 Batas Pambansa bilang 130 on August 21, 1981. All issues arising from labor and employment shall be subjected to mandatory conciliation mediation. The labor arbiter or the appropriate dole, agency, or office that has jurisdiction over the dispute shall entertain only endorsed or referred cases by the duly authorized officer. And an example for this is may isang company na tawagin na lang natin Antipid, and doon nagtatrabaho sa employee na tawagin natin si Mr. Bartolina is magrereklamo siya sa isang officer sa BLR na tumatanggap ng mga kaso na pangalanan na lang natin si Miss anong problema. And si Mr. Bartolina is pupunta siya kay Miss anong problema, and Miss anong problema will be the one who will endorse you to the arbiter na si Mr. Bactol. And hindi po pwedeng tumanggap ng cases si Mr. Bactol nang hindi siya fully endorsed by Miss anong problema. And in Article 235, issuance of subpoena, the Bureau shall have the power to require the appearance of any person or the production of any paper, document, or matter relevant to a labor dispute under its jurisdiction, either at the request of any interested party or at its own initiative. Dito naman po it is formal written orders that requires a person to appear before the court or other legal proceedings. Si BLR ay meron siyang kapangyarihan na tumawag ng tao para humarap sa kanila at maglabas ng kinakailangang dokumento para sa kaso. Example is, notice siya na binibigay sa iyo or sa isang tao para ikaw ay humarap or ikaw pumunta ka sa harap ng korte for legal proceedings.
According to the Article 236 of the Appointment of Bureau Personnel, the Secretary of Labor and Employment has the power to add to the present personnel of someone as a personnel that could execute the purpose of the code, such as the numbers of examiners and other assistant that has been needed in the Bureau of Employment. Article 237, Registry of Unions and File of Collective Bargaining Agreements. This says that the Bureau of Relations should have all the registry of legitimate of labor unions, which has had the power to operate, shall have also the file of all the records of all the agreements, of the all collective bargaining agreements, and also issues of settlements of disputes regarding labor. The files are open for all the parties under the condition by the Secretary of Labor and Employment. And it should only be disclosed if there is concerning with the public and national security. It's the only way that it could be disclosed. According to the Article 237, in addition to that, within 30 days of the execution of the collective bargaining agreement, they should already have to submit a copy to the Bureau of Regional Office of the Department of Labor and Employment for a registration. A copy for it for such a registration. They should also have verified proofs or evidence of posting in too conspicuous or places which are very visible, eye-catching, or noticeable, that all workers will be able to see the bargaining agreement. It is also stated in there that the regional offices have 5 calendar days to be able to have a copy of the collective bargaining agreement to be served within 5 days of submission. It is also said that the Bureau of Regional Offices should have an assessment to the employer of getting registration fee, that it should not be less than 1,000 pesos for the collective bargaining that was been registered. It also have to be appropriate and necessary, that was been able to be approved by the Secretary of Labor of Employment for a good governance, or like a efficient and effective way of administration on the voluntary arbitration program. The amount that was being collected to the people of that was part of it will be going to the Special Voluntary Arbitration Fund. The Bureau shall also have all the files and undertake assist on publication of final decision. It was said that it should have copy, but it should also have the publication, or making it showing to the public, accessible to the public, of the final decisions and orders or any awards of the Secretary of Labor and Employment, regional directors in the Commission, as it was said as amended by the Section 15 Republic Act 9 number 6715 on March 21, 1989. In Article 238, Provisions for Certification of Election, the Bureau of Labor and Relations should not entertain any petition of certification, election, or any actions which may disturb the administration of duly registered elective bargaining agreements affecting the parties under Article 253, which means the Article 253 is the right to self-organization, unless there's things like that. And also 256, which stated the effect of inclusion on as members of the employee outside the bargaining unit. It's all like the exception in this prohibition. Article 239, Privileged Communication, the information a statement made at conciliation or the mediator proceedings shall be a privileged communication, as something like a more private files or documents, and shouldn't be used against the Commission. And conciliator shall not be witnesses or testify to any court regarding that matter that was been where the conciliation proceedings were conducted by them